Number 1. Miranda versus Arizona, the birth of your rights. In the early morning hours of March 13, 1963, an 18-year-old woman was abducted while walking home from her job at a movie theater in Phoenix, Arizona, driven to the desert and sexually assaulted before being released. 10 days later, Phoenix police arrested Ernesto Miranda, a 23-year-old truck driver with a prior record for minor offenses, after the victim identified his vehicle and he was placed in a lineup where she made a tentative identification. What happened next in the interrogation room would ultimately transform American criminal procedure in ways that continue to resonate more than half a century later, establishing protections that millions of Americans now take for granted whenever they watch a police procedural on television or find themselves in contact with law enforcement. Miranda was taken into interrogation room number 2 at Phoenix Police Headquarters, where 2 detectives questioned him for approximately 2 hours without informing him of his right to remain silent or his right to have an attorney present during questioning. The interrogation was not recorded, and no attorney was provided or requested. Though Miranda had not graduated from high school and had no sophisticated understanding of his constitutional rights under the Fifth Amendment's protection against self-incrimination or the Sixth Amendment's guarantee of legal counsel. At the end of this session, Miranda signed a written confession that included a typed paragraph stating that the confession was made voluntarily, without threats or promises, and with full knowledge of his legal rights, though investigators never actually explained what those rights were. Based primarily on this confession, Miranda was convicted of kidnapping and rape and sentenced to 20 to 30 years in prison on each count, to run concurrently. His court-appointed attorney, Alvin Moore, argued that the confession should have been excluded from evidence because Miranda had not been informed of his constitutional rights, but both the trial court and the Arizona Supreme Court upheld the conviction, ruling that Miranda's rights had not been violated because he had not specifically requested an attorney and had not been physically coerced or tortured into confessing. The case then moved to the United States Supreme Court, where it was consolidated with 3 other similar cases involving confessions obtained without proper warnings about constitutional rights. Chief Justice Earl Warren, writing for a 5-4 majority in a decision issued on June 13, 1966, held that the Fifth Amendment's protection against self-incrimination required law enforcement officers to advise suspects of certain rights before conducting custodial interrogations. The court recognized that the inherently coercive nature of police custody and interrogation created psychological pressures that could overwhelm a person's will and produce involuntary confessions, even without physical brutality or explicit threats. To counteract this coercion and ensure that any waiver of Fifth Amendment rights was knowing, intelligent, and voluntary, the court established what became known as Miranda warnings or Miranda rights, requiring police to inform suspects that they have the right to remain silent, that anything they say can be used against them in court, that they have the right to an attorney, and that an attorney will be provided if they cannot afford one. The decision further specified that if a suspect invokes either the right to silence or the right to counsel at any point during questioning, interrogation must cease immediately, and any statements obtained in violation of these requirements would be inadmissible in court regardless of their truthfulness or the severity of the crime being investigated. The ruling sparked intense controversy, with critics arguing that it would handcuff law enforcement and allow guilty criminals to escape justice through technicalities, while supporters celebrated it as a crucial protection of individual liberty against government overreach. In the decades since Miranda, the decision has become deeply embedded in American legal culture and popular consciousness, with the familiar warnings appearing in countless television shows, movies, and news reports. The Supreme Court has refined and clarified Miranda's requirements in numerous subsequent cases, creating exceptions for public safety emergencies, defining what constitutes custodial interrogation, and addressing questions about when and how suspects can waive their rights or reinitiate contact with police after invoking them. Despite periodic calls for its overruling and several cases that narrowed its scope, the core of Miranda remains intact, recently reaffirmed by the court even as its composition has grown more conservative. Ironically, Ernesto Miranda himself never benefited from the landmark ruling that bears his name. His confession was excluded at his retrial, but prosecutors obtained a new conviction based on other evidence, including testimony from his common-law wife that he had admitted the crime to her, and he served 11 years in prison before being paroled in 1972. For years after his release, Miranda was stabbed to death in a bar fight in Phoenix at age 34, and when police arrested suspects in his killing, they read them their Miranda rights, a darkly poetic conclusion to the story of the man whose case transformed American criminal procedure. The broader impact of Miranda extends beyond its specific legal requirements to represent a cultural touchstone about the balance between effective law enforcement and individual rights, a reminder that even those accused of terrible crimes retain constitutional protections, and a practical framework that has shaped how millions of interrogations have been conducted over the past 6 decades. The decision exemplifies how a single case involving an individual defendant with limited education and a serious criminal charge can produce systemic changes that affect the entire justice system, protecting not just the guilty but also the innocent who might otherwise be pressured into false confessions, and ensuring that the government's legitimate interest in solving crimes operates within constitutional constraints that preserve human dignity and autonomy even in moments of greatest vulnerability. Number 2. Gideon versus Wainwright, the right to an attorney for all. On June 3, 1961, a burglary occurred at the Bay Harbor pool room in Panama City, Florida, a minor crime involving the theft of a small amount of money and some beer and wine from a cigarette machine and jukebox, the kind of offense that might ordinarily receive little attention beyond local police reports and brief court proceedings. The person arrested and charged with this petty crime was Clarence Earl Gideon, a 51-year-old drifter with an 8th-grade education and a lengthy criminal record consisting primarily of nonviolent property crimes. A man who had spent much of his adult life in and out of prisons, living on the margins of society with few resources and little power. When Gideon appeared in court for his trial on August 4, 1961, he asked the judge to appoint an attorney to represent him because he could not afford to hire one himself, a reasonable request given the complexity of criminal procedure and the serious consequences of conviction, even for a relatively minor felony. Judge Robert McCrary Jr. denied the request, explaining that under Florida law, court-appointed counsel was provided to indigent defendants only in capital cases where the death penalty might be imposed, not in ordinary felony prosecutions, regardless of the defendant's poverty or lack of legal knowledge. This policy was consistent with established legal precedent, including the Supreme Court's 1942 decision in Betts v. Brady, which held that the Sixth Amendment's guarantee of legal counsel applied to state criminal proceedings only in special circumstances where lack of representation would result in fundamental unfairness, such as when the defendant was mentally incompetent or the case involved particularly complex legal issues. Forced to represent himself, Gideon conducted his own defense as best he could, cross-examining the state's witnesses, presenting his own witnesses, and making arguments to the jury, but his lack of legal training and courtroom experience placed him at a severe disadvantage against the prosecutor, who had years of legal education and professional experience. The jury found Gideon guilty, and Judge McCrary sentenced him to the maximum penalty of 5 years in state prison, a harsh punishment for stealing what amounted to perhaps $50 or $60 worth of money and alcohol. Rather than accepting his fate, Gideon used his time in Florida State Prison to study law in the prison library, teaching himself legal research and writing skills that most people acquire only through years of formal education and professional training. He filed a petition for habeas corpus in the Florida Supreme Court arguing that his conviction was unconstitutional because he had been denied his Sixth Amendment right to counsel, but that court denied relief, finding no error in the trial court's application of existing law. Undeterred, Gideon then prepared and filed a handwritten petition for certiorari to the United States Supreme Court, a 5-page document written in pencil on prison stationery that made a simple but powerful argument. The right to counsel is fundamental to a fair trial, and states should not be permitted to prosecute and imprison people who are too poor to hire attorneys while denying them legal representation. In an extraordinary turn of events, the Supreme Court agreed to hear Gideon's case, one of only a tiny fraction of petitions that the court accepts each term, and appointed Abe Fortas, a prominent Washington attorney who would later become a Supreme Court justice himself, to represent Gideon before the court. On March 18, 1963, the Supreme Court issued a unanimous decision authored by Justice Hugo Black, who had dissented 21 years earlier in Betts v. Brady, explicitly overruling that precedent and holding that the Sixth Amendment's guarantee of legal counsel is a fundamental right essential to a fair trial that applies to state criminal prosecutions through the 14th Amendment's Due Process Clause. The court recognized that lawyers in criminal courts are necessities, not luxuries, and that even intelligent and educated defendants would be at a substantial disadvantage without legal representation given the complexity of criminal law, the technical rules of evidence and procedure, and the prosecution's professional expertise. Justice Black wrote that reason and reflection require recognition that in our adversary system of criminal justice, any person hauled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided, making the right to counsel one of the safeguards deemed necessary to ensure fundamental human rights of life and liberty. The decision required states to provide attorneys to indigent defendants in all felony cases, fundamentally transforming criminal justice by establishing public defender systems and court-appointed counsel programs across the nation. Following the Supreme Court's ruling, Gideon received a new trial, this time represented by a local attorney who effectively cross-examined witnesses and presented a defense that raised reasonable doubt about Gideon's guilt, resulting in an acquittal after the jury deliberated for only 1 hour. Gideon walked out of the courthouse a free man on August 5, 1963. Having spent nearly 2 years in prison for a crime he may not have committed, punished in part because the state denied him the legal assistance that might have prevented his initial conviction. The broader impact of Gideon versus Wainwright has been immeasurable, extending the right to counsel to millions of poor defendants and creating a constitutional floor beneath which states cannot fall in their treatment of accused persons. The decision led to the establishment of public defender offices in jurisdictions across America, the development of standards for effective assistance of counsel, and subsequent Supreme Court rulings extending the right to counsel to misdemeanor cases that carry potential jail time and to critical stages of criminal proceedings beyond trial, such as preliminary hearings, plea negotiations, and first appeals as of right. However, the promise of Gideon has often exceeded its reality, as public defender systems remain chronically underfunded, forcing attorneys to handle crushing caseloads that make meaningful representation difficult and sometimes impossible. Studies have documented public defenders handling hundreds or even thousands of cases simultaneously, with severely limited time for investigation, research, and client consultation, raising questions about whether Gideon's guarantee of counsel has become, in too many cases, merely a guarantee of a warm body with a law degree rather than effective advocacy. Clarence Earl Gideon himself lived only 3 more years after his acquittal, dying of cancer in 1972 at age 61, never wealthy or famous but forever remembered as the man whose handwritten prison petition established one of the most important constitutional protections in American criminal law. His case demonstrates how fundamental rights can emerge from the most unlikely sources, how a poorly educated defendant with nothing but time, determination, and access to a prison library can spark a constitutional revolution, and how the Supreme Court can recognize and correct injustices that had been accepted as normal for generations. The legacy of Gideon continues to shape debates about criminal justice reform, the quality of indigent defense, and the meaning of equal justice under law, reminding us that constitutional rights are only as strong as our commitment to making them real in the lives of the poorest and most vulnerable members of society. Number 3. Terry versus Ohio Stop and Frisk enters constitutional law. On October 31, 1963, Cleveland Police Detective Martin McFadden, a 39-year veteran of the police force who worked the downtown beat and had developed what he described as an intuitive sense for suspicious behavior through decades of observation and experience, noticed 2 men standing on a street corner at the intersection of Huron Road and Euclid Avenue in downtown Cleveland, engaging in conduct that struck him as peculiar and potentially preparatory to a crime. The 2 men, John Terry and Richard Chilton, were walking back and forth along the same route repeatedly, pausing to peer into the window of a jewelry store, then walking to the end of the block where they would confer with each other before making another pass by the store window, a pattern they repeated approximately a dozen times over a 10 or 12-minute period. Detective McFadden, dressed in plain clothes and observing from a position where he could watch without being conspicuous, suspected the men were casing the store for a robbery, though he had no specific information about any planned crime and the men had not yet committed any illegal act that he could observe. When a third man joined the other 2, and all 3 walked down the street together, McFadden decided to approach them, identifying himself as a police officer and asking their names. When the men mumbled something unintelligible rather than providing clear answers, McFadden grabbed Terry, spun him around, and patted down the outside of his clothing, a quick frisk that immediately revealed a pistol in Terry's overcoat pocket. McFadden removed the gun and then patted down the other 2 men, finding another pistol on Chilton but no weapon on the third man, Katz. McFadden then took all 3 men inside a nearby store and conducted more thorough searches, confirming that Terry and Chilton each had concealed firearms but finding no other weapons or contraband. Terry and Chilton were arrested and charged with carrying concealed weapons, a felony under Ohio law, and they moved to suppress the evidence of the guns, arguing that McFadden's stop and frisk violated the Fourth Amendment's prohibition against unreasonable searches and seizures because the detective had no probable cause to arrest them or search them before he found the weapons. The trial court denied the motion to suppress, finding that McFadden had reasonable grounds to believe the men were acting suspiciously, and that his limited pat-down search for weapons was justified by concern for his own safety and the safety of others in the area. Both defendants were convicted, with Terry receiving a sentence of 1 to 3 years in prison, and both appealed, arguing that the Fourth Amendment required probable cause before any search could occur, and that the concept of a limited protective search based on mere suspicion was unconstitutional. The Ohio Court of Appeals and the Ohio Supreme Court both upheld the convictions, and the case proceeded to the United States Supreme Court, which agreed to address the question of whether police officers could briefly detain and search suspects based on something less than probable cause when they had reasonable grounds to believe criminal activity was afoot and the suspects might be armed and dangerous. On June 10, 1968, the Supreme Court issued an 8-1 decision authored by Chief Justice Earl Warren, holding that the Fourth Amendment allows police officers to conduct brief investigatory stops of individuals based on reasonable suspicion that criminal activity is occurring, and to conduct limited pat-down searches for weapons if they have reasonable grounds to believe the person may be armed and dangerous, even without the probable cause that would be required for a full arrest or complete search. The court recognized the reality that police officers must be able to investigate suspicious circumstances and protect themselves and others from potential violence without always meeting the higher standard of probable cause, which might be impossible to establish until after a crime has been committed or a dangerous situation has escalated. Chief Justice Warren emphasized that the frisk authorized by this decision must be limited in scope to a pat-down of outer clothing designed to detect weapons, not a general exploratory search for evidence of crime, and that the justification for the frisk must be independent of the justification for the stop. An officer might have reasonable suspicion to stop someone for investigation but still lack grounds to frisk unless there are specific reasons to believe the person is armed. The court carefully explained that reasonableness under the Fourth Amendment depends on balancing the government's interest in effective law enforcement and officer safety against the individual's interest in personal security and privacy, and that a brief detention and limited weapons frisk represents a minimal intrusion justified by important governmental interests when based on articulable facts rather than mere hunches or generalizations. The Terry decision created what became known as a Terry stop or stop and frisk, a law enforcement tool that has become routine in American policing but also enormously controversial, particularly regarding its application in minority communities. In the decades following Terry, courts have expanded and refined the doctrine, addressing questions about how long a Terry stop can last before it becomes an arrest requiring probable cause, what kinds of facts can establish reasonable suspicion, whether officers can search areas beyond outer clothing during a Terry frisk, and how the initial stop and frisk doctrines apply to vehicles, luggage, and other contexts beyond pedestrian encounters on city streets. The stop and frisk power has been credited by many law enforcement officials and some researchers with helping to reduce crime by allowing officers to proactively investigate suspicious behavior and remove illegal weapons from the streets before they are used in violent crimes. However, the practice has also been heavily criticized and the subject of civil rights litigation in cities, including New York, where a federal court found that the NYPD's stop and frisk program was implemented in a manner that violated the constitutional rights of minorities through racial profiling and stops that lacked the reasonable suspicion required by Terry. Data from New York and other cities has shown that stops are disproportionately concentrated in minority neighborhoods, and that the vast majority of stops do not result in arrests or the discovery of weapons or contraband, raising questions about whether the practice as actually implemented serves legitimate law enforcement purposes, or instead represents harassment of innocent people based on their race and neighborhood. The Terry decision itself acknowledged these concerns to some extent, noting that the exclusionary rule, which requires suppression of evidence obtained through unconstitutional searches, would apply to Terry stops and frisks, theoretically deterring police from conducting unjustified stops since any evidence discovered would be inadmissible in court. However, critics point out that this deterrent effect is limited because most Terry stops do not result in the discovery of evidence or lead to prosecutions. So the exclusionary rule provides no remedy for the vast majority of people who are stopped without reasonable suspicion and suffer the indignity and inconvenience of being detained and searched without any legal recourse. The case illustrates the ongoing tension in Fourth Amendment law between granting police the flexibility they need to prevent crime and protect public safety versus limiting their power to intrude on individual liberty and privacy without solid evidence of wrongdoing. Detective McFadden's observations and actions on that October day in Cleveland seemed reasonable given his experience and the specific facts he witnessed, and his instincts were validated when he found that 2 of the 3 men were indeed carrying concealed weapons. But the broader authority created by Terry has been applied in millions of encounters where officers' suspicions were less well-founded and where no evidence of criminal activity was ultimately discovered. The balance struck by Terry remains a subject of active debate more than half a century after the decision, particularly as questions of police practices, racial justice, and constitutional rights have moved to the center of American political discourse, making this case not just a historical artifact but a living source of law that continues to shape daily interactions between police and citizens across the nation. Number 4. Mapp versus Ohio. The exclusionary rule goes nationwide. On May 23, 1957, Cleveland police officers received information that a bombing suspect might be hiding in the home of Dalry Mapp, a 35-year-old African-American woman who lived in a 2-family house on Milverton Road in a predominantly white neighborhood on Cleveland's east side. When officers arrived and knocked on Mapp's door around 1 o'clock in the afternoon, she called her attorney and then refused to let them enter without a search warrant, a reasonable exercise of her Fourth Amendment rights that might have ended the encounter had the police simply obtained a warrant or left the premises. Instead, the officers maintained surveillance of the house for approximately 3 hours while additional officers arrived, and when Mapp's attorney appeared at the house around 4 o'clock, the police prevented him from entering or consulting with his client. Shortly thereafter, officers forcibly entered the home by breaking a door or window. Accounts vary on the specific method of entry, and when Mapp confronted them demanding to see their warrant, one officer displayed a piece of paper that he claimed was a warrant but which was never produced at trial and apparently did not actually exist. Mapp grabbed the paper and stuffed it down her blouse, leading to a physical struggle during which officers handcuffed her and retrieved the document, then conducted a thorough search of the entire house including her bedroom, her daughter's bedroom, the kitchen, the dinette, the living room, and the basement. The search did not uncover the bombing suspect or any evidence related to the bombing investigation, which had served as the purported justification for seeking entry to the home, but in a trunk in the basement officers found obscene materials including lewd and lascivious books, pictures, and photographs, the possession of which was illegal under Ohio law. Mapp was arrested and charged with possession of obscene materials, and she moved to suppress the evidence on the grounds that it had been obtained through an illegal search conducted without a valid warrant and without her consent. The trial court denied the motion, finding that even if the search was illegal under the Fourth Amendment, Ohio law at that time did not require exclusion of illegally obtained evidence in state criminal prosecutions, following the principle established by the Supreme Court in Wolf v. Colorado that while the Fourth Amendment applied to the states through the 14th Amendment, states were not required to exclude evidence obtained in violation of the Fourth Amendment as long as they provided some other remedy for unconstitutional searches. Mapp was convicted and sentenced to an indeterminate term of 1 to 7 years in the Ohio Reformatory for Women, a harsh punishment for possession of materials that would be fully protected by the First Amendment only a few years later, and she appealed her conviction through the Ohio court system without success. The case eventually reached the United States Supreme Court, which initially agreed to hear it on First Amendment grounds regarding the obscenity conviction, but during oral argument and in its ultimate decision, the court shifted focus to the Fourth Amendment question of whether the exclusionary rule should be applied to state criminal prosecutions. On June 19, 1961, the Supreme Court issued a 6-3 decision authored by Justice Tom Clark, overruling Wolf v. Colorado and holding that evidence obtained in violation of the Fourth Amendment must be excluded from state criminal trials, extending to state prosecutions the exclusionary rule that had applied to federal prosecutions since the court's 1914 decision in Weeks v. United States. Justice Clark's opinion emphasized that the right to privacy protected by the Fourth Amendment would be empty and meaningless if violated rights produced no consequences for the government, and that without the exclusionary rule to deter unconstitutional searches and incentivize compliance with Fourth Amendment requirements, police would have little reason to respect constitutional limits on their search and seizure authority. The court recognized that alternative remedies for Fourth Amendment violations, such as civil lawsuits against officers or criminal prosecution of officers who conducted illegal searches, had proven ineffective in practice because juries were often reluctant to rule against police officers. Qualified immunity doctrines protected officers from liability in many circumstances, and prosecutors rarely brought criminal charges against law enforcement personnel. The exclusionary rule, by making illegally obtained evidence inadmissible regardless of its truthfulness or its importance to proving guilt, created a powerful incentive for police departments to train officers in proper procedures, establish protocols for obtaining warrants, and supervise officers to ensure constitutional compliance. The decision provoked immediate and lasting controversy, with critics arguing that the rule allowed guilty criminals to escape justice because of police mistakes or technicalities, leading to the famous complaint that under the exclusionary rule the criminal goes free because the constable blundered. Supporters countered that the rule was essential to maintaining constitutional limits on government power, protecting individual liberty from overzealous law enforcement, and ensuring that courts would not become parties to unconstitutional conduct by accepting and acting upon evidence obtained through rights violations. In the decades following MAP, the Supreme Court has repeatedly addressed challenges to the exclusionary rule, creating exceptions for good faith reliance on defective warrants, evidence that would have been inevitably discovered through legal means, situations where the connection between the illegal search and the discovery of evidence is too attenuated to justify suppression, and instances where evidence is used for impeachment rather than in the prosecution's case in chief. These exceptions have narrowed the exclusionary rule's scope and reduced its impact on criminal prosecutions, reflecting changing judicial philosophies and growing skepticism about whether the rule effectively deters police misconduct given that individual officers rarely face personal consequences when evidence is suppressed. Despite these limitations, the core of MAP remains intact, requiring suppression of evidence obtained through egregious Fourth Amendment violations and maintaining the principle that constitutional rights must have meaningful remedies. Research on the exclusionary rule's effectiveness has produced mixed results, with some studies suggesting it has led to improved police training and more careful attention to Fourth Amendment requirements, while other research indicates that evidence suppression is relatively rare and that the rule's deterrent effect may be limited by officers' beliefs that they will not be caught violating rights, or that prosecutors will find ways to use evidence despite suppression motions. Dalry Mapp herself had an interesting life after her landmark case, winning her appeal and having her obscenity conviction overturned, but later being arrested in New York in 1970 on drug charges and convicted of possession of stolen property. Serving time in prison before her release and eventual move to Queens, where she lived quietly until her death in 2014 at age 91, having secured her place in constitutional history even as she struggled with the law in her personal life. Her case represents a fundamental tension in American criminal justice between the competing values of effective crime control and constitutional constraint on government power, a tension that continues to generate debate and litigation as courts attempt to determine how strictly to enforce Fourth Amendment requirements in an era of evolving surveillance technologies, expanding police powers, and persistent concerns about both crime rates and police accountability. The MAP decision illustrates how constitutional law develops through the resolution of specific factual situations that may seem unremarkable at first glance, but that raise fundamental questions about the relationship between individuals and the state, questions that are answered through judicial reasoning that extends far beyond the particular parties involved to establish rules that will govern millions of future cases and shape the daily operations of law enforcement agencies across the nation. Number 5. Brady versus Maryland, the duty to disclose exculpatory evidence. In the early morning hours of June 27, 1958, John Brady and his companion Charles Boblet picked up their acquaintance Donald Brooks in Baltimore, Maryland, drove him to a secluded area, and murdered him by strangulation, though which of the two men actually killed Brooks remained a disputed question that would become central to Brady's legal appeals. Brady and Boblet were arrested and charged with first-degree murder, and before trial, Brady's attorney made a request to examine Boblet's extrajudicial statements to police, seeking information that might help Brady's defense or provide mitigating evidence that could spare him from the death penalty, even if he was convicted. Prosecutors turned over some of Boblet's statements but withheld a confession in which Boblet admitted to the actual killing, information that could have been crucial to Brady's defense strategy and sentencing because under Maryland law at the time, a defendant convicted of first-degree murder could receive either the death penalty or life imprisonment depending on the jury's recommendation, and evidence that Brady was not the actual killer might have persuaded the jury to show mercy even if they convicted him of felony murder as an accomplice. Brady's attorney pursued a strategy of conceding guilt but arguing for life imprisonment rather than death, emphasizing that Brady had not personally killed the victim and should therefore receive a lesser punishment than death, but without access to Boblett's confession explicitly admitting that he alone committed the strangulation. This argument was weakened and made less persuasive to the jury. Brady was convicted of first-degree murder, and the jury recommended the death penalty, which the trial court imposed, sentencing Brady to be executed for his role in Brooks's murder. Only after Brady's conviction and sentencing did his attorneys discover the existence of Boblett's confession acknowledging that he alone had killed Brooks, and they immediately moved for a new trial on the grounds that the prosecution's suppression of this exculpatory evidence violated Brady's due process rights under the 14th Amendment. The Maryland Court of Appeals held that while the suppression was indeed a violation of due process, the remedy should be limited to a new sentencing hearing rather than a new trial on guilt, reasoning that Brady had already admitted his participation in the robbery and other circumstances surrounding Brooks's murder, so the suppressed evidence would not have affected the jury's determination of guilt even if it might have influenced their sentencing recommendation. The case reached the United States Supreme Court on the question of what prosecutors' obligations are to disclose evidence favorable to defendants and what remedies should be available when prosecutors fail to meet these obligations. On May 13, 1963, the Supreme Court issued a 7-2 decision authored by Justice William Douglas, holding that suppression by the prosecution of evidence favorable to an accused violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution, establishing what became known as the Brady Rule or Brady Disclosure Requirement. Justice Douglas emphasized that the purpose of a criminal trial is justice, not merely conviction, and that society wins not only when the guilty are convicted but also when criminal trials are fair, making it fundamentally unfair for prosecutors to withhold evidence that could exonerate defendants or reduce their punishment. The court recognized that prosecutors occupy a unique position in the adversarial system, with access to investigative resources and evidence that defendants often cannot obtain on their own, creating a power imbalance that can only be partially addressed by requiring prosecutors to share evidence that tends to negate guilt or mitigate punishment. The decision established that Brady violations occur when three elements are present. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it can be used for impeachment of prosecution witnesses. The evidence must have been suppressed by the prosecution, whether willfully or inadvertently, and the evidence must be material, meaning there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. This materiality standard has been the subject of extensive subsequent litigation, with courts attempting to define when suppressed evidence is important enough to require reversal of a conviction or sentence versus when the suppression, though improper, was harmless error that did not affect the outcome. The Brady Rule has been expanded and refined through numerous subsequent Supreme Court decisions, including United States v. Agers, which clarified prosecutors' disclosure obligations even when defense attorneys make no specific requests for evidence. United States v. Bagley, which extended Brady to impeachment evidence that could be used to undermine prosecution witnesses' credibility. Kiles v. Whitley, which held that prosecutors are responsible for disclosing favorable evidence in the possession of police and other government agents, not just evidence in prosecutors' personal files. And Banks v. Dreck, which addressed situations where prosecutors actively conceal Brady material or mislead courts about its existence. Despite these elaborations of the Brady Rule, compliance remains inconsistent and violations continue to occur with troubling regularity, sometimes because individual prosecutors intentionally suppress favorable evidence in pursuit of convictions, but more often because of systemic factors such as inadequate training, poor communication between police and prosecutors about what evidence exists, disagreements about what evidence is material enough to require disclosure, and organizational cultures that prioritize conviction rates over fairness. Studies of exonerations have found that prosecutorial suppression of evidence is one of the leading causes of wrongful convictions, present in a substantial percentage of cases where innocent people were convicted and later exonerated through DNA evidence or other means, highlighting the real-world consequences when the Brady Rule is not effectively enforced. The remedy for Brady violations remains contested, with some courts treating every suppression of favorable evidence as requiring reversal while others engage in harmless error analysis that asks whether the defendant would likely have been convicted or received the same sentence anyway even if the evidence had been disclosed. An inquiry that critics argue places too much weight on judges' speculation about hypothetical alternative outcomes and too little weight on the fundamental unfairness of trials conducted without access to material evidence. Some jurisdictions have implemented open-file discovery policies that require prosecutors to turn over their entire case file to the defense, reducing opportunities for Brady violations by eliminating prosecutorial discretion about what must be disclosed. Though these policies can create practical challenges regarding voluminous materials, witness privacy and safety, and work product protections. The American Bar Association and other professional organizations have adopted ethical rules requiring prosecutors to disclose evidence favorable to defendants, and some states have gone beyond constitutional minimums to create statutory discovery obligations that are broader than Brady requires, but enforcement of these rules and statutes varies widely, and prosecutors are rarely disciplined for Brady violations, even when courts find that violations occurred. John Brady himself ultimately benefited from the Supreme Court decision that bears his name, receiving a new sentencing hearing at which he was again sentenced to death. But his sentence was later commuted to life imprisonment when Maryland temporarily abolished capital punishment, and he was eventually paroled after serving time in prison, though Charles Boblet, who actually committed the killing and whose confession had been withheld, was executed in Maryland's gas chamber on August 1, 1959, before the Supreme Court ruling. The Brady decision represents an attempt to address the fundamental information asymmetry in criminal cases, where the government controls the investigative process and has access to evidence that defendants cannot obtain through their own efforts, creating conditions where miscarriages of justice can easily occur if prosecutors are permitted to cherry-pick which evidence to disclose and which to suppress. The case illustrates the often overlooked reality that prosecutors' professional responsibilities extend beyond winning convictions to ensuring fair processes and just outcomes, a responsibility that can conflict with institutional pressures to maintain high conviction rates, political pressures to appear tough on crime, and human tendencies toward confirmation bias and selective attention to evidence supporting predetermined conclusions. The ongoing prevalence of Brady violations decades after the Supreme Court's landmark decision suggests that constitutional rights are only as effective as the mechanisms for enforcing them, and that noble principles announced in judicial opinions must be translated into practical training, institutional practices, and accountability systems if they are to meaningfully protect the rights of real defendants in actual criminal cases rather than existing merely as aspirational ideals in legal textbooks. Number 6. Batson versus Kentucky challenging racial discrimination in jury selection. James Kirkland Batson, a black man, was indicted in Jefferson County, Kentucky on charges of second-degree burglary and receipt of stolen goods. Routine criminal charges that could have been resolved through plea bargaining or a quick trial with little public attention, but that instead became the vehicle for a landmark Supreme Court ruling on racial discrimination in jury selection that fundamentally changed how criminal trials are conducted across America. During jury selection for Batson's trial, the prosecutor used peremptory challenges, which allow attorneys to exclude potential jurors without stating reasons, to strike all 4 black members of the jury venire, the pool of potential jurors from which the trial jury would be selected, resulting in an all-white jury despite Batson being black and despite the fact that the community from which jurors were drawn included substantial numbers of African American citizens who were eligible and available for jury service. Batson's attorney immediately objected, arguing that the prosecutor's use of peremptory challenges to remove all black jurors violated Batson's Sixth Amendment right to a jury drawn from a fair cross-section of the community and his 14th Amendment right to equal protection under the law, but the trial judge denied the objection, noting that under existing Supreme Court precedent established in Swain v. Alabama, defendants challenging racial discrimination in jury selection had to prove a pattern of discrimination across multiple cases over time, not just systematic exclusion of minorities from their particular trial. Unable to meet this extraordinarily difficult burden of proof, which required access to records from numerous cases and statistical evidence of discrimination that few defendants could reasonably obtain, Batson's objection was overruled, and his trial proceeded with an all-white jury that convicted him of both charges. Batson appealed, and after the Kentucky Supreme Court upheld his conviction, finding no constitutional violation under existing precedent, the case reached the United States Supreme Court, which agreed to consider its earlier ruling in Swain and address whether that decision had created an unworkable standard that effectively immunized racial discrimination in jury selection from meaningful legal challenge. On April 30, 1986, the Supreme Court issued a 7-2 decision authored by Justice Lewis Powell, overruling the aspects of Swain that required proof of systematic exclusion across multiple cases and establishing a new framework for challenging discriminatory use of peremptory strikes. The court held that the Equal Protection Clause forbids prosecutors from challenging potential jurors solely on account of their race, or on the assumption that black jurors as a group will be unable to impartially consider the state's case against a black defendant, and that defendants can establish a prima facie case of discrimination by showing that they are members of a cognizable racial group, that the prosecutor has exercised peremptory challenges to remove members of that group from the jury venire, and that these facts and any other relevant circumstances raise an inference that the prosecutor excluded jurors on account of their race. Once a defendant makes this prima facie showing, the burden shifts to the prosecutor to articulate race-neutral reasons for the strikes, explanations that must be more than mere denials of discriminatory intent or conclusory statements but that need not rise to the level of justification required for a challenge for cause, which requires showing actual bias or inability to be impartial. If the prosecutor provides facially neutral reasons, the trial court must then determine whether the defendant has proven purposeful discrimination, evaluating whether the prosecutor's stated reasons are pretextual, and whether the real motivation for the strikes was racial bias. This framework, which became known as the Batson test or Batson challenge, has been applied in thousands of cases since 1986 and has been extended beyond race-based strikes to include discrimination based on gender and ethnicity. However, the effectiveness of Batson in eliminating discrimination from jury selection has been seriously questioned by judges, scholars, and civil rights advocates who have documented that prosecutors continue to strike minority jurors at disproportionate rates and that trial courts rarely find Batson violations even when the patterns of strikes strongly suggest racial motivation. The fundamental problem with Batson lies in the ease with which attorneys can construct race-neutral explanations for striking jurors, offering reasons such as demeanor, lack of eye contact, criminal history of family members, employment status, or other factors that may themselves correlate with race and that are difficult for defendants to rebut as pretextual. Studies have found that in many jurisdictions, prosecutors successfully defend against Batson challenges in the vast majority of cases by offering explanations that trial judges accept even when the explanations seem weak or inconsistent, and that appellate courts almost always defer to trial courts' factual findings about whether discrimination occurred, creating multiple layers of deference that make it extremely difficult to obtain reversal based on Batson violations. Some prosecutors have been recorded in training sessions explicitly discussing how to articulate race-neutral reasons for strikes that are actually motivated by racial bias, and investigations have uncovered written materials from prosecutors' offices instructing attorneys on how to circumvent Batson by fabricating neutral-sounding justifications for discriminatory strikes. These revelations have led some courts and commentators to conclude that Batson has failed to achieve its goal of eliminating racial discrimination from jury selection and that more drastic reforms are needed, such as eliminating peremptory challenges entirely, requiring prosecutors to use strikes randomly rather than selectively, or shifting the burden of proof to require prosecutors to affirmatively demonstrate that strikes were not racially motivated rather than merely requiring defendants to prove discrimination. Several jurisdictions have taken steps in these directions, with Washington State's Supreme Court adopting a rule that presumes certain reasons for striking jurors are invalid, and that allows Batson challenges based on implicit bias even without proof of conscious discrimination, and California eliminating the requirement that defendants prove purposeful discrimination, and instead allowing challenges based on whether an objective observer could view race or ethnicity as a factor in the exercise of peremptory challenges. The persistence of racial discrimination in jury selection, more than 3 decades after Batson, reflects deeper structural problems in the criminal justice system, including unconscious bias among prosecutors and judges, lack of diversity within prosecutors' offices and the judiciary, inadequate training on implicit bias and the historical legacy of race discrimination in jury service, and insufficient accountability for attorneys who engage in discriminatory jury selection. The Supreme Court itself has acknowledged concerns about Batson's effectiveness, with Justice Thurgood Marshall writing in his concurring opinion in Batson that the decision did not go far enough, and that the only way to eliminate racial discrimination in jury selection would be to abolish peremptory challenges altogether, a position that subsequent justices have echoed in various opinions expressing frustration with the continued prevalence of discrimination despite Batson's prohibition. James Batson's own case concluded with a new trial following the Supreme Court's decision, but the ultimate outcome of that trial is not well documented in legal records, and Batson himself, unlike some other defendants whose names became attached to landmark Supreme Court decisions, did not become a public figure or advocate for criminal justice reform. The Batson decision illustrates both the potential of constitutional litigation to address systemic injustice and the limitations of formal legal rights when they are not backed by effective enforcement mechanisms and when they rely on subjective determinations by actors who may themselves harbor conscious or unconscious biases. The case remains centrally important in American criminal procedure, invoked in countless trials every year when defense attorneys challenge jury selection practices. But its legacy is complicated by the reality that discrimination continues despite the protections it established, reminding us that announcing constitutional principles is only the first step toward achieving equal justice and that vigilant enforcement and continuing reform are necessary to make those principles meaningful in practice. Number 7. Roper versus Simmons, ending juvenile executions. On September 9, 1993, 17-year-old Christopher Simmons, along with two younger friends aged 15 and 16, broke into the home of Shirley Crook in Jefferson County, Missouri, bound the 46-year-old woman with electrical cable and duct tape, drove her to a state park, and threw her off a railroad trestle into the Merrimack River where she drowned, a horrific crime that Simmons had apparently planned in advance and had discussed with friends, telling them they could get away with it because they were minors. Simmons was arrested the following day after one of his accomplices confessed and implicated him, and Simmons himself quickly gave a videotaped confession describing the crime in detail and expressing no remorse, even offering to reenact the crime for investigators, which he did on camera, demonstrating a shocking lack of empathy or understanding of the gravity of what he had done. The brutality of the crime and Simmons's apparent callousness made him an unsympathetic defendant, and prosecutors charged him as an adult with first-degree murder, seeking the death penalty despite his age at the time of the offense. Missouri law permitted capital punishment for offenders who were 16 or 17 at the time of their crimes, consistent with Supreme Court precedent established in Stanford v. Kentucky, which had held in 1989 that executing 16 and 17-year-old offenders did not violate the Eighth Amendment's prohibition against cruel and unusual punishment because there was no clear national consensus against the practice. Simmons was convicted after a trial in which the jury heard evidence of his confession, testimony from his accomplices, and physical evidence linking him to the crime, and during the penalty phase the prosecution emphasized the calculated nature of the crime, Simmons's lack of remorse, and aggravating factors that made him deserving of death rather than life imprisonment. The defense presented mitigating evidence including Simmons's age, his difficult family background, and expert testimony about adolescent brain development and the reduced culpability of juvenile offenders, but the jury recommended death and the trial court imposed a death sentence. Simmons's appeals through the Missouri court system were unsuccessful, with courts rejecting his arguments that executing juvenile offenders violated the Eighth Amendment and that developments in neuroscience and psychology regarding adolescent brain development should be considered in assessing the constitutionality of juvenile capital punishment. However, between Simmons's initial conviction and his final appeals, the legal and scientific landscape began to shift, with the Supreme Court deciding Atkins v. Virginia in 2002, which prohibited execution of intellectually disabled offenders based on evolving standards of decency, and with accumulating scientific research documenting that adolescent brains are not fully developed, particularly in areas responsible for impulse control, risk assessment, and long-term planning. Armed with this new evidence and encouraged by the reasoning in Atkins, Simmons's attorneys filed a new petition arguing that the same logic that prohibited executing the intellectually disabled should also prohibit executing juvenile offenders, given that both groups have diminished capacity for mature judgment and reduced culpability for their actions. The Missouri Supreme Court agreed, vacating Simmons's death sentence and resentencing him to life imprisonment without possibility of parole, finding that a national consensus had developed against executing juvenile offenders, and that the practice violated the Eighth Amendment's prohibition against cruel and unusual punishment. The state of Missouri appealed to the United States Supreme Court, which agreed to hear the case and reconsider its earlier decision in Stanford v. Kentucky. On March 1, 2005, the Supreme Court issued a 5-4 decision authored by Justice Anthony Kennedy, holding that the 8th and 14th Amendments forbid imposition of the death penalty on offenders who were under the age of 18 when their crimes were committed, explicitly overruling Stanford v. Kentucky and establishing 18 as a bright-line rule below which capital punishment is categorically unconstitutional. Justice Kennedy's opinion emphasized three key differences between juvenile and adult offenders that made juvenile executions disproportionate and therefore cruel and unusual. First, juveniles have a lack of maturity and an underdeveloped sense of responsibility that often results in impetuous and ill-considered actions. Second, juveniles are more vulnerable to negative influences and outside pressures, including peer pressure, and have less control over their own environment. And third, the character of juveniles is not as well formed as that of adults, meaning their actions are less likely to be evidence of irretrievably depraved character and more likely to reflect transient immaturity. The court also relied on evidence of evolving standards of decency, noting that a significant majority of states had either abolished the death penalty entirely or prohibited its use for juvenile offenders, that even in states where juvenile execution was theoretically permitted it was rarely imposed and even more rarely carried out, and that the United States was isolated internationally in its willingness to execute juvenile offenders, with virtually every other nation in the world prohibiting the practice. The decision sparked intense debate, with supporters praising it as a recognition of scientific reality and moral progress, while critics condemned it as judicial activism that improperly elevated the court's own moral preferences over democratic judgments made by state legislatures, and that selectively relied on international law and practices that the court ignored in other contexts. The four dissenting justices, led by Justice Antonin Scalia, argued that there was no clear consensus against juvenile execution sufficient to justify finding an Eighth Amendment violation, that the court was improperly substituting its own judgment for that of juries and legislatures, and that the categorical rule announced by the majority was inconsistent with the individualized sentencing required in capital cases, where juries should be permitted to consider a defendant's youth as a mitigating factor but should not be barred from imposing death when they find it appropriate after considering all circumstances. The Roper decision had immediate practical effects, removing 72 juvenile offenders from death rows across the country and ensuring that no one could be executed for crimes committed before age 18, regardless of how heinous the crime or how mature the offender. The decision also influenced subsequent juvenile justice jurisprudence, providing a foundation for the court's later decisions in Graham v. Florida, which prohibited life without parole for juvenile non-homicide offenders, and Miller v. Alabama, which prohibited mandatory life without parole sentences for juvenile homicide offenders and required that sentencing courts consider youth and its attendant characteristics before imposing the harshest possible punishment. These cases collectively represent a trend toward recognizing that children are constitutionally different from adults for purposes of criminal punishment, that the penological justifications for harsh punishments apply with less force to juvenile offenders, and that the criminal justice system must account for diminished culpability and greater capacity for rehabilitation when dealing with youthful defendants. Scientific research on adolescent brain development has continued to accumulate since Roper, with neuroscientists using advanced imaging techniques to document that the prefrontal cortex, which is responsible for executive functions like planning, impulse control, and weighing consequences, does not fully mature until the mid-20s, raising questions about whether even young adults in their late teens and early 20s should be treated differently from older defendants in terms of punishment severity. Christopher Simmons remains in prison serving his life sentence, now in his late 40s, and advocates for juvenile justice reform sometimes point to cases like his as evidence that even offenders who commit terrible crimes as teenagers can mature and change over decades of incarceration. Though Simmons himself has not become a public advocate for reform and details of his current status and rehabilitation are not widely publicized. The case of Shirley Crook's murder remains a tragedy, and her family's loss cannot be diminished by legal or scientific arguments about the appropriate punishment for her killer, illustrating the tension between society's legitimate desire to punish wrongdoing severely and the recognition that children and teenagers are different from adults in ways that should affect their criminal liability. The Roper decision represents the Supreme Court's willingness to reconsider and overrule its own recent precedents when convinced that constitutional understanding has evolved, that new scientific evidence warrants reconsideration of legal conclusions, or that national and international consensus has shifted sufficiently to justify changing course. Though critics argue that this approach to constitutional interpretation gives too much weight to temporary fluctuations in public opinion and too little weight to the principles of stare decisis that promote stability and predictability in law. The prohibition on juvenile executions established by Roper is now firmly embedded in American constitutional law, widely accepted even by many who initially opposed the decision, and unlikely to be overturned even as the court's composition has become more conservative, suggesting that some constitutional developments, once established, become part of the permanent legal landscape regardless of changing political circumstances. Number 8. District of Columbia versus Heller, the Second Amendment as an individual right. For most of American history, the Second Amendment to the United States Constitution, which provides that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed, was understood primarily as protecting the right of states to maintain militias rather than as guaranteeing an individual right to possess firearms unconnected to militia service, a reading supported by the amendment's reference to militias and by the Supreme Court's 1939 decision in United States v. Miller, which analyzed Second Amendment questions through the lens of militia utility. This understanding began to be challenged in the late 20th century by legal scholars, gun rights advocates, and some courts that argued the amendment's text, history, and structure actually protected an individual right to keep and bear arms for purposes including self-defense, hunting, and resistance to tyranny, independent of any connection to organized militia service. The question of which interpretation was correct remained largely academic until the District of Columbia adopted some of the nation's strictest gun control laws in 1976, essentially banning handgun possession by private citizens, requiring that firearms in homes be kept unloaded and disassembled or bound by a trigger lock, and creating a licensing system that in practice prevented virtually anyone from legally possessing operable firearms for self-defense within their homes. Dick Heller, a special police officer authorized to carry a handgun while on duty at the Federal Judicial Center, applied for a registration certificate to keep a handgun in his home for self-defense purposes, following all required procedures and meeting all eligibility criteria, but the district denied his application pursuant to its general prohibition on handgun registration. Heller, supported by the Libertarian Cato Institute and other gun rights organizations, filed a lawsuit challenging the district's gun laws as violating the Second Amendment, arguing that the amendment protected an individual right to possess functional firearms in the home for self-defense, and that the district's near-total ban on such possession exceeded constitutional bounds. The federal district court dismissed Heller's complaint, but the D.C. Circuit Court of Appeals reversed, holding that the Second Amendment does protect an individual right to possess firearms unconnected to militia service, and that the district's prohibition on handguns and requirement that lawful firearms be kept non-functional violated this right. The District of Columbia appealed to the Supreme Court, which agreed to hear the case and definitively resolve the meaning of the Second Amendment for the first time in nearly 70 years. On June 26, 2008, the Supreme Court issued a 5-4 decision authored by Justice Antonin Scalia, holding that the Second Amendment guarantees an individual right to possess firearms independent of service in a militia and to use those arms for traditionally lawful purposes such as self-defense within the home, and that the district's ban on handgun possession and requirement that lawful firearms be rendered inoperable violated this right. Justice Scalia's opinion employed extensive historical analysis, examining the amendment's text, the public understanding of the right to keep and bear arms at the time of ratification, state constitutional provisions, legal commentaries, and historical practices to conclude that the amendment codified a pre-existing right understood by the founding generation as belonging to individuals. The opinion acknowledged that the amendment's prefatory clause about militias announces a purpose but does not limit or expand the scope of the operative clause protecting the right to keep and bear arms, comparing it to saying a well-educated electorate, being necessary to self-governance, the right of the people to attend schools shall not be infringed, which would still protect a right to attend schools even for purposes unrelated to election participation. The court held that the core Second Amendment right is the right of law-abiding, responsible citizens to use arms in defense of hearth and home, and that handguns are the quintessential self-defense weapon whose prohibition would fail any standard of scrutiny. However, the court carefully emphasized that its decision did not cast doubt on long-standing prohibitions on firearms possession by felons and the mentally ill, laws forbidding carrying firearms in sensitive places like schools and government buildings, laws imposing conditions on commercial sale of firearms, or laws banning certain dangerous and unusual weapons not commonly possessed by law-abiding citizens for lawful purposes. Justice Scalia noted that like most rights, the Second Amendment right is not unlimited and that regulatory measures would be permitted as long as they did not infringe upon the core right to possess handguns in the home for self-defense. The 4 dissenting justices, in opinions authored by Justices John Paul Stevens and Stephen Breyer, argued that the majority had misread the Second Amendment's text and history, that the amendment was intended to protect the right to possess and use firearms in connection with militia service rather than for purely private purposes, and that even if an individual right existed, the district's gun laws represented a reasonable regulation that should be upheld given the serious problem of gun violence and the district's authority to protect public safety. The Heller decision immediately became one of the most consequential and controversial Supreme Court rulings in modern American law, praised by gun rights advocates as vindicating the original meaning of the Constitution and condemned by gun control supporters as inventing a new individual right without historical foundation and handcuffing democratic efforts to address gun violence. The decision spawned hundreds of legal challenges to gun regulations across the country, with lower courts left to determine how to apply Heller's holding to laws regulating magazine capacity, assault weapons, concealed carry, open carry, gun-free zones, and numerous other contexts not directly addressed by the Supreme Court's opinion. 2 years after Heller, the Supreme Court decided McDonald v. City of Chicago, which incorporated the Second Amendment against the states through the 14th Amendment, extending Heller's individual rights interpretation beyond the unique federal jurisdiction of Washington, D.C. to apply nationwide and striking down Chicago's handgun ban. However, the court provided relatively little guidance about the appropriate standard of review for gun regulations, declining to specify whether laws should be evaluated under strict scrutiny, intermediate scrutiny, or some other framework, and causing confusion and inconsistency among lower courts attempting to apply Heller to various regulatory schemes. Some circuits upheld many gun regulations by reasoning that they did not burden the core Second Amendment right identified in Heller, while other circuits struck down similar laws by applying more demanding scrutiny and requiring stronger governmental justifications. This inconsistency persisted for more than a decade until the Supreme Court decided New York State Rifle and Pistol Association v. Bruin in 2022, which clarified that Second Amendment cases should be analyzed by first determining whether the regulated conduct falls within the amendment's plain text and then examining whether the regulation is consistent with the nation's historical tradition of firearms regulation, rejecting means-end scrutiny frameworks and requiring the government to justify regulations by reference to historical analogs. The Bruin decision further strengthened Second Amendment protections and led to successful challenges against various state and local gun laws, though questions remain about how courts should identify relevant historical traditions and how they should apply 18th and 19th century regulatory practices to modern firearms and modern conditions. The impact of Heller and its progeny on actual gun violence and public safety remains a subject of intense empirical debate, with some research suggesting that right-to-carry laws and reduced gun regulations correlate with increased violent crime, while other studies find no such relationship or even identify crime-reducing effects, and with the methodological challenges of isolating the effects of gun laws from other factors making definitive causal conclusions difficult. Dick Heller himself largely retreated from public life after his landmark victory, occasionally giving interviews about his case but not becoming a major political figure or activist, though he did file subsequent lawsuits challenging other D.C. gun regulations, with mixed success in those efforts. The Second Amendment jurisprudence established by Heller represents one area where constitutional law has moved in a distinctly libertarian direction, expanding individual rights against government regulation, while most other areas of constitutional law have seen contraction of limits on governmental power, creating an interesting tension in conservative legal philosophy between skepticism of unenumerated rights like privacy while enthusiastically recognizing and expanding the Second Amendment right to bear arms. The cultural and political salience of gun rights has only intensified since Heller, with the Second Amendment becoming a central issue in political campaigns, a litmus test for judicial nominees, and a rallying point for both gun rights advocates who see firearms ownership as essential to liberty and self-reliance and gun control supporters who view high levels of gun violence as a uniquely American tragedy requiring stronger regulation. The Heller decision illustrates how constitutional interpretation can fundamentally reshape law and policy, settling, or at least claiming to settle, questions that had been subject to political negotiation and democratic decision-making, and converting them into constitutional mandates that limit the options available to legislators and voters, while also demonstrating how the court's composition and interpretive methodologies profoundly affect which rights receive robust protection and which governmental interests receive deference. Number 9. Gideon v. Wainwright and Argesinger v. Hamlin, attorneys for misdemeanors. while Gideon versus Wainwright established the constitutional right to court-appointed counsel for indigent defendants facing felony charges. A significant gap remained in Sixth Amendment protection for people charged with misdemeanors, less serious offenses that nonetheless could result in incarceration and criminal records that would affect employment, housing, and numerous other aspects of life for years after conviction. John Richard Argasinga found himself caught in this gap when he was charged in Florida State Court with carrying a concealed weapon, a misdemeanor punishable by up to 6 months in jail and a $1,000 fine. Charges that, while less serious than felonies, still carried substantial potential consequences for someone without resources to hire private counsel. Argasinga, who was indigent and could not afford an attorney, requested that the court appoint counsel to represent him, but the trial judge denied this request, noting that Florida law and Supreme Court precedent only required appointment of counsel in cases where the defendant faced potential imprisonment of more than 6 months, categorizing such offenses as felonies while treating shorter-term imprisonment offenses as misdemeanors, not triggering the Sixth Amendment right to counsel. Forced to represent himself without legal training or understanding of courtroom procedures and evidence rules, Argasinga was convicted after a bench trial and sentenced to 90 days in jail, a significant deprivation of liberty imposed without the assistance of counsel that Gideon had established was necessary for a fair trial in felony cases. Argasinga appealed his conviction, arguing that the Sixth Amendment right to counsel should not turn on the formal classification of an offense as a felony or misdemeanor, but rather on the actual penalty imposed, and that any case resulting in imprisonment of a defendant who was denied counsel violated the constitutional guarantee of effective assistance, regardless of whether the offense charged was labeled a felony or a misdemeanor by state law. The Florida District Court of Appeal affirmed the conviction, finding no constitutional violation under existing precedent, but the case reached the United States Supreme Court, which agreed to address whether the right to counsel extended to misdemeanor cases that could result in incarceration. On June 12, 1972, the Supreme Court issued a unanimous decision authored by Justice William Douglas, holding that absent a knowing and intelligent waiver, no person may be imprisoned for any offense, whether classified as petty, misdemeanor, or felony, unless he was represented by counsel at his trial. The court reasoned that the legal and constitutional questions involved in a misdemeanor case can be as complex as those in felony prosecutions, that many misdemeanor charges carry serious collateral consequences beyond the immediate penalty, and that the assistance of counsel is essential to ensuring fair proceedings regardless of the formal classification of charges. Justice Douglas emphasized that the basic protections of the Sixth Amendment are not diminished simply because the possible penalty for a particular offense is less than 6 months of imprisonment, and that the guiding principle must be the actual consequences faced by defendants rather than arbitrary classifications established by legislatures. The decision established a bright-line rule. If a defendant is actually sentenced to imprisonment, even for just a day, the conviction cannot stand unless the defendant was represented by counsel or intelligently and knowingly waived the right to representation. This rule provided clear guidance to trial courts and ensured that no one would lose their liberty as a result of criminal proceedings conducted without legal representation or valid waiver. However, Argasinga left open an important question. What about defendants who face potential imprisonment but ultimately receive only fines or probation? Could they be tried without counsel as long as the court did not actually impose jail time? The Supreme Court addressed this question in Scott v. Illinois, where it held that the right to appointed counsel applies only in cases where the defendant is actually imprisoned, not merely where imprisonment is an authorized penalty, meaning that states could try indigent misdemeanor defendants without appointing counsel as long as judges committed not to impose any jail time if conviction resulted. This narrower interpretation of Argasinga created practical challenges, as defendants and their attorneys needed to know at the outset of proceedings whether jail time was a possibility in order to assert the right to counsel, and trial judges needed to determine before trial whether they might want to impose incarceration based on facts and aggravating circumstances that might only become clear during the proceedings. Some states responded by adopting broader rules than Scott required, guaranteeing counsel in all cases where imprisonment is authorized regardless of whether it is actually imposed, while others followed Scott's narrower interpretation, leading to variations in access to counsel across jurisdictions. The implications of Argasinga and Scott extend beyond the courtroom to affect how misdemeanor justice functions in America, a system that processes millions of cases annually, often through rushed proceedings where defendants spend only minutes before a judge, and where the volume of cases makes individualized attention difficult even when counsel is provided. Studies of misdemeanor courts have documented assembly line justice where public defenders meet clients for the first time minutes before hearings, where guilty pleas are entered en masse without meaningful attorney-client consultation, and where the presumption of innocence and right to trial are more theoretical than real given the practical pressures to accept plea bargains and move cases quickly through overwhelmed court systems. The right to counsel announced in Argasinga, while vitally important in principle, has often failed to translate into effective representation in practice, as jurisdictions provide woefully inadequate funding for misdemeanor defense, assign overwhelming caseloads to public defenders handling misdemeanor cases, and create systemic incentives for quick guilty pleas rather than careful investigation and vigorous advocacy. Research has shown that many misdemeanor defendants, even those represented by appointed counsel, spend more time in pretrial detention than they would serve if convicted and sentenced to the maximum penalty for their alleged offense, making the right to counsel somewhat hollow when defendants feel compelled to plead guilty just to get out of jail regardless of whether they actually committed the alleged offense. Argasinga decision represents constitutional law's recognition that liberty is precious regardless of whether deprivation comes through felony or misdemeanor proceedings, and that the complexity of legal processes requires professional assistance for fair adjudication regardless of the severity of charges. John Richard Argasinga himself benefited directly from the Supreme Court's ruling, having his conviction reversed, though records of the ultimate disposition of his case and his life after the landmark decision are not readily available in public documents. The case illustrates the often overlooked reality that misdemeanor convictions, despite carrying lighter sentences than felonies, can have devastating consequences for defendants including incarceration, fines that indigent people cannot afford to pay leading to additional penalties and collection problems, loss of professional licenses, immigration consequences including deportation for non-citizens, and criminal records that create barriers to employment, housing, education, and public benefits for years or decades after the case concludes. The Supreme Court's misdemeanor right to counsel jurisprudence, established through Argasinga and refined through subsequent cases, represents an attempt to ensure that constitutional protections apply throughout the criminal justice system rather than only to the most serious offenses, though the gap between constitutional promise and practical reality remains substantial in many misdemeanor courts where the volume of cases and scarcity of resources prevent the kind of individualized attention and zealous advocacy that effective assistance of counsel should entail. Number 10. Brown versus Mississippi Coerced Confessions and Due Process. In March 1934, in rural Kemper County, Mississippi, a white farmer named Raymond Stewart was murdered in his home, and suspicion quickly fell on 3 black sharecroppers: Ed Brown, Henry Shields, and Yank Ellington, men who had no meaningful legal rights or social status in a Jim Crow Mississippi county where racial hierarchy was enforced through violence and terror. Deputy Sheriff Dial and other law enforcement officers arrested Ellington and took him to Stewart's home, where they accused him of the murder and began beating him when he denied involvement, hanging him from a tree by a rope around his neck, letting him down, and hanging him again when he continued to maintain his innocence, repeating this lynching simulation several times before releasing him with instructions to return a few days later with a confession. When Ellington appeared as ordered, still maintaining his innocence, the officers whipped him severely, cutting his back to ribbons with a leather strap with buckles on it, and continuing to beat him until he agreed to confess to whatever version of events the officers dictated. Brown and Shields were subjected to similarly brutal treatment, beaten with leather straps with metal buckles, whipped until their backs were cut and bleeding, and told that the beatings would continue until they confessed to the murder in exactly the language the officers provided. The 3 men, terrified for their lives and in extraordinary physical pain, eventually gave confessions exactly as dictated by their torturers, implicating themselves and each other in Stewart's killing even though they were almost certainly innocent of the crime. At their trial, which began on April 5, 1934, just over a month after the alleged murder and barely enough time for their wounds from the beatings to begin healing, the prosecution's case consisted almost entirely of these confessions, as there was virtually no other evidence linking the defendants to the crime. The defense attorney attempted to exclude the confessions on the ground that they had been obtained through torture and were therefore involuntary and unreliable. And during testimony about the beatings, one deputy sheriff openly admitted whipping Ellington but justified it by saying, "Not too much for a Negro, not as much as I would have done if it were left to me," a shocking acknowledgement that exposed the casual brutality and racism pervading law enforcement in Mississippi at that time. Despite this admission of torture and the visible scars still marking the defendants' backs, the trial judge allowed the confessions into evidence, and the all-white jury, likely composed of men who accepted racial violence as normal and necessary for maintaining white supremacy, deliberated for less than half an hour before convicting all three defendants of murder. The trial court sentenced Brown, Shields, and Ellington to death, to be hanged for Stewart's murder based on confessions beaten out of them through what any reasonable person would recognize as torture. The defendants appealed to the Mississippi Supreme Court, which affirmed the convictions in a decision that barely acknowledged the beatings and certainly did not treat them as constitutionally problematic, reflecting the state court's comfort with and complicity in the racial terror system that governed Mississippi. The case then reached the United States Supreme Court on petition for certiorari, with the defendants represented by attorneys from the NAACP and other civil rights organizations who saw the case as an opportunity to establish federal constitutional limits on state law enforcement brutality. On February 17, 1936, the Supreme Court issued a unanimous decision authored by Chief Justice Charles Evans Hughes, reversing the convictions and holding that the use of confessions obtained through physical torture violates the Due Process Clause of the 14th Amendment, making trials based on such confessions fundamentally unfair regardless of the defendant's actual guilt or innocence. Chief Justice Hughes wrote that it would be difficult to conceive of methods more revolting to the sense of justice than those taken to procure the confessions in this case, and that the rack and torture chamber may not be substituted for the witness stand, even in a state prosecution for a serious crime. The court emphasized that coerced confessions are both unreliable, since people will say anything to stop torture, and fundamentally at odds with the concept of due process, which requires fair procedures and prohibits convictions based on evidence obtained through government brutality. The decision marked one of the court's first significant uses of the 14th Amendment's Due Process Clause to impose constitutional limits on state criminal procedures, beginning a long line of cases that would eventually incorporate most of the Bill of Rights criminal procedure protections against the states and establish federal constitutional standards for police interrogations, searches, trials, and punishments. Brown v. Mississippi did not immediately end coercive interrogation practices or transform policing in Mississippi and other southern states, where racial violence and legal injustice continued for decades, but it established a constitutional principle that courts could invoke to review and occasionally reverse the most egregious examples of official brutality, creating at least some federal check on state law enforcement abuses. The case influenced the development of the voluntariness test for confessions, under which courts examined the totality of circumstances surrounding a confession to determine whether it was the product of free will or coercion, considering factors such as the duration of interrogation, the use of physical or psychological pressure, the defendant's age and education, access to counsel, and whether the defendant was informed of constitutional rights. This voluntariness approach governed confession admissibility for 3 decades until Miranda v. Arizona established more specific requirements for custodial interrogations, though voluntariness remains relevant even after Miranda as courts continue to examine whether confessions were truly voluntary or were coerced through psychological manipulation, false promises, or conditions that overwhelmed the defendant's will. Ed Brown, Henry Shields, and Yank Ellington had their convictions reversed and were not retried, ultimately going free though their lives had been devastated by months of terror, torture, and the prospect of execution for a crime they did not commit. And the actual killer of Raymond Stewart, if different from the 3 accused men, was never identified or prosecuted, leaving the case unsolved despite the horrific injustice inflicted on innocent men in the name of solving it. The broader significance of Brown v. Mississippi extends beyond the specific facts of torture and false confessions to represent the Supreme Court's recognition that fair criminal procedure is a constitutional requirement, not merely a privilege that states may grant or withhold at their discretion, and that federal courts have both the authority and the obligation to protect individual rights against state government abuse, even when such protection contradicts local customs and challenges entrenched power structures. The case illustrates the central role that race and racism have played in American criminal justice, with black defendants especially vulnerable to police brutality, coerced confessions, inadequate legal representation, all-white juries, and harsh punishments that reflected white supremacist assumptions about black criminality and the expendability of black lives. The constitutional protections established in Brown and subsequent cases have benefited defendants of all races, but they were often developed in response to particularly egregious mistreatment of black defendants in southern states where legal systems operated more as instruments of racial control than as neutral mechanisms for determining guilt and administering justice. The evolution from Brown's prohibition on physical torture to Miranda's requirement of warnings and waiver to contemporary debates about psychological interrogation techniques and false confessions demonstrates that ensuring voluntary and reliable confessions remains an ongoing challenge requiring constant attention from courts, legislators, and law enforcement administrators. The promise of Brown, that government may not use torture to obtain convictions, seems almost self-evident from a contemporary perspective. Yet the persistence of police brutality, coercive interrogation tactics, and wrongful convictions based on false confessions suggests that the underlying problems Brown addressed have not been fully resolved, and that vigilance remains necessary to protect the rights of the accused against government overreach and abuse.